Today we are going to briefly explain what the Party Wall Act is, why it is needed, and how this relates to you when planning an extension, what your responsibilities are, and why it's important that you take those responsibilities seriously. Party wall legislation dates back to 1666, when the Great Fire of London devastated the city and changed how the design and construction of buildings in London was regulated. Out of this disaster came the London Rebuilding Act 1667, which aimed to prevent the spread of fire between adjacent buildings. Several amendments later came through the London Building Acts, which are still in action under present legislation. Previous legislation was predominantly restricted to work within London and provided limited framework for resolving disputes in relation to construction adjacent to neighbouring properties. This resulted in expensive and drawn-out litigation to resolve disputes, often involving relatively straightforward matters. As such, the Party Wall, etc. Act 1996 was introduced, superseding local acts. The Party Wall Act aimed to enable building owners in England and Wales to proceed with their proposed works, provide a framework to resolve disputes between parties, and protect adjoining owners. Often we find that building owners who want to construct extensions to their property see the Party Wall Act as an unnecessary cost and another legislative hurdle to jump through, causing time delays to their project. However, it is important to understand that the Act is designed to enable and facilitate building owners to proceed with their works and not prevent them from carrying them out. So whilst many people may feel negative about the Act, it's actually a very positive piece of legislation designed to help you proceed with your work. When building an extension, the notifiable elements of work tend to be in relation to building a new wall on the line of junction, the boundary between you and your neighbour, and the excavation for the construction of new foundations in close proximity to your neighbour's building. We do also see instances where your extension may also affect a party wall itself. However, this is much more common with works such as loft conversions, where you may need to cut into the party wall to insert steel beams. If you have a semi-detached house or terrace house and you are planning a rear extension, you will almost definitely need to serve a party wall notice on your neighbour. However, if you have a detached house that is set back from your neighbour's property and your extension is not built up to the line of junction, you may not need to serve a party wall notice at all. Whether your works are notifiable largely depends on how close your excavations are to your neighbour's building and how deep your foundations will be. This is where it is extremely important to seek the advice of an experienced party wall surveyor to review your proposals. They will be able to tell you whether your works are notifiable or not. A common misconception about the Party Wall Act is that it only affects properties with a shared party wall. However, this is not true. When constructing extensions, it is often not about shared walls, but instead about the foundations and the potential damage that can be caused to a neighbour's building when excavating below the depth of a neighbouring building's foundations. At Harris & Clark, we often recommend that when carrying out notifiable works, you should consider instructing a photographic schedule of condition on your neighbour's property, even if they consent to your party wall notices. By documenting the condition of their property prior to construction works, this will provide evidence should they believe damage has been caused to their property. This protects your neighbour and builds trust in the relationship, but also protects you from any spurious claims of damage. If you're planning to make the most of the space available to you and construct your foundation on the boundary line, you will need to serve a party wall notice on your neighbour. Importantly, if you want to build the new wall of your extension astride the boundary line, this new wall will be a party wall, and you can only do this with your neighbour's written consent. This is because you have no right to build astride the boundary. So if your neighbour refuses, you will need to modify your design proposals. This highlights the importance in seeking the advice of an experienced party wall surveyor early on. We also recommend that you open a line of communication with your neighbour prior to serving notices to see whether they would have any objections to you building astride the boundary, as this may prevent time delays and additional costs in modifying your design. It is worth speaking to your architect to determine whether they would charge additional fees in modifying the position of your extension should your neighbour object to building astride the boundary. If you plan to build the new wall wholly on your own land, but up to the boundary line, you must still serve a party wall notice, but your neighbour will not be able to stop this proposal. Whilst you do have the right to build your extension up to the boundary line, and if your neighbour agrees astride the boundary, that does not necessarily mean you have the right to build your foundations on their land. The Party Wall Act does permit you to construct your foundations for a new wall on your neighbour's land, but only where necessary. We find that in almost all cases, eccentric foundations can be designed to ensure that your foundations do not encroach on your neighbour's land. We have a helpful video on eccentric foundations, however, we're also happy to discuss this option with you on the phone. Another point to consider is that you have no right to allow your gutters, soffits or fascias to overhang the boundary. This could be considered trespass under common law and is not recommended. If you do overhang the boundary and your neighbour decides to build their own extension in the future, the Party Wall Act will give them the right to cut off any projections preventing them from constructing their own extension, potentially causing you issues and disputes further down the line. If you're planning to build an extension and you need expert advice on how the Party Wall Act relates to your proposals, contact our team of Party Wall Surveyors at Harris & Clark on 023 8155 0051. We look forward to speaking with you about how we can help you build your new extension.